non-disclosure orders. Was Speaker McCarthy a flight risk?
The non-disclosure order was based on concerns about
Was Speaker McCarthy a flight risk?
He was not.
He was not. Then why did your non-disclosure order refer to him as a flight risk? It says right here, the court finds reasonable grounds to believe that such disclosure will result in flight from prosecution.
Sir, when securing a non-disclosure order, the risks don't have to be
You
associated.
think that the Speaker of the House is a flight risk?
The question?
No, this is not your time. This is my time. You think the Speaker of the House is a flight risk? You think he's going to hop on a plane and leave the country?
Texas, Mr. Gill is recognized for 5 minutes.
Mr. Smith, in January of 2023, did you subpoena then Speaker of the House Kevin McCarthy's toll records?
Yes, sir, we did.
Yes, you did. And the subpoena covered the time period between November 2020 and January 2021. Is that right?
I'm sorry, sir, could you say that again?
We're not going to delay like this. The subpoena covered the time period between November of 2020 and January 2021. How many days after Kevin McCarthy was sworn in as Speaker did you subpoena his records?
I don't recall, but those two things had nothing to
It
do
was
with one.
16 days after becoming the highest-ranking Republican in the House of Representatives. You subpoenaed his toll records. Do you agree that that might reasonably be considered a violation of the speech or debate clause?
I do not, and I want to be clear that the toll
You were
records...
collecting months' worth of phone data on the Republican Speaker of the House, the leader of the opposition, right after he got sworn in as Speaker, all around the time of a major vote. That sounds like a flagrant violation of the speech or debate clause to me, and I think most people agree with me. And Speaker McCarthy had no recourse, did he? Because you issued a non-disclosure order ensuring that neither he nor any of the American people knew about these subpoenas. Is that right?
The toll record, the non-content toll record subpoenas, we did secure non-disclosure orders for those subpoenas.
You did, and let me ask you, Mr. Smith, at the time you secured those non-disclosure orders, was Speaker McCarthy a flight risk?
The non-disclosure order was based on concerns about...
Was Speaker McCarthy a flight risk?
He was not.
He was not. Then why did your non-disclosure order refer to him as a flight risk? It says right here, the court finds reasonable grounds to believe that such disclosure will result in flight from prosecution.
Sir, when securing a non-disclosure order, the risks don't have to be
You
associated...
think that the Speaker of the House is a flight risk?
The question?
No, this is not your time. This is my time. You think the Speaker of the House is a flight risk? You think he's going to hop on a plane and leave the country?
No, what I was trying to explain is, with respect to a non-disclosure order, the risks aren't necessarily associated with the subscriber to the phone. They're the risks to the investigation.
I think that you were using, this was clearly in reference to Speaker McCarthy, and you were using clearly false information to secure a non-disclosure order to hide from Speaker McCarthy and from the American people the fact that you were spying on his toll records. But I've got more, so let's move on. In May of 2023, you also issued subpoenas for toll records of 9 U.S. senators and an additional representative. Is that right?
In May of 23, we did issue...
You did, and there were non-disclosure orders in conjunction with those subpoenas as well, right?
That's correct, consistent with department policy and
Right.
the law.
So again, nobody would know what you were doing. The senators would, and the representatives would, and the American people wouldn't know what you were doing. Is that right?
The toll records that we secured and the non-disclosure orders were consistent with policy and consistent...
And you knew whenever you were doing that there was a risk you were violating the speech or debate clause. Is that right?
The toll record subpoenas that we secured were with the concurrence of the public integrity...
Your own analysis says that you knew there was a risk you were violating the speech or debate clause. I have it right here. This is an email from John Keller at Public Integrity Section to your team. As you are aware, quote, as you are aware, there is some litigation risk regarding whether compelled disclosure of toll records of a member's legislative calls violates the speech or debate clause in the D.C. Circuit. That's from your own analysis right there. So you did know, didn't you?
Sir, with respect to the item you just put up on the screen, the last sentence states...
Oh, we're going to get to the last sentence.
Okay.
We're going to get to the last sentence. And you cite case law in here, quote, the bar on compelled disclosure is absolute. Is that right? Or do you think that you didn't have to abide by that precedent?
To be clear, this statement is not from my office. This is the statement of public
This is
integrity
your
section.
justification for those subpoenas and NDOs that you ordered. This was part of your analysis. It's a cursory analysis. I think it's worth noting. But let's get to that last sentence then. Quote, given my understanding of the low likelihood that any of the members listed below would be charged, the litigation risk should be minimal here. In other words, you're using a novel legal theory, which you knew was novel, has never been tested by any court. You're not charging any of these members. Nobody's going to know about it because you issued NDOs. Nobody's going to sue this, so who cares? We're going to do it anyways. I mean, you walked all over the Constitution throughout this entire process.
Mr. Chairman, the gentleman's time has
spying
expired.
on members of Congress, and you know it. It's absolutely disgraceful. I yield back.
All right, everyone, welcome back. Turn your volume up and watch the screen closely, because what we are unpacking today is a completely explosive, high-stakes constitutional showdown from a House Judiciary Committee hearing. We are looking at freshman Representative Brandon Gill of Texas absolutely grilling former Special Counsel Jack Smith. This isn't just your standard partisan bickering. This transcript reveals a fundamental battle over the separation of powers, executive overreach, and the terrifying reality of federal prosecutors secretly vacuuming up the communications data of the highest-ranking lawmakers in the United States government without their knowledge. Gill is systematically laying out a paper trail that suggests the Special Counsel's office weaponized routine judicial boilerplate and non-disclosure orders to spy on the opposition leadership while deliberately hiding it from the courts, the members of Congress, and the American public. Let's dive into our first deep look, the speech or debate clause versus executive subpoenas. Gill opens the interrogation by dropping a chronological bombshell. He establishes that a mere 16 days after Kevin McCarthy was sworn in as Speaker of the House, Jack Smith's office slapped a phone carrier with a subpoena for McCarthy's non-content toll records. The time frame targeted was between November 2020 and January 2021, the volatile period surrounding the events of January 6. Gill asks point blank if targeting the records of a sitting speaker constitutes a flagrant violation of the speech or debate clause under Article 1 of the Constitution. For those who need a quick refresher, the speech or debate clause is an absolute constitutional shield designed to protect lawmakers from executive branch intimidation. It ensures that prosecutors cannot comb through a congressman's legislative communications to build a criminal case or exert political pressure. Smith instantly pushes back, denying any violation, but Gill zeroes in on the chilling reality of how this operation was conducted. McCarthy had absolutely no legal recourse to fight it because Smith's team secured a strict non-disclosure order, NDO. The phone company was legally gagged, meaning the leader of the legislative branch was being actively monitored by the executive branch with zero awareness of the intrusion. Now let's look at the absolute peak of the tension in this hearing, the moment that is going to set the comment section on fire, the flight risk legalese trap. At the 1:32 mark, Gill sets a beautiful trap regarding the legal justification used to obtain that secrecy order. He asks Smith, was Speaker McCarthy a flight risk? Smith is forced to admit, he was not. Then Gill pulls out the court documents and reads the justification Smith's team submitted to the judge under penalty of perjury. The court finds reasonable grounds to believe that such disclosure will result in flight from prosecution. Watch how fast Smith tries to scramble into technical abstractions. He argues that when securing an NDO, the boilerplate statutory risks listed in the motion don't necessarily apply to the specific subscriber of the phone, they apply to the integrity of the broader investigation. In other words, Smith is trying to claim that using a generic form that labels Kevin McCarthy a flight risk is just standard, harmless Department of Justice paperwork. But Gill completely rejects this explanation, cutting him off mid-sentence with a biting counterpunch. You think the Speaker of the House is going to hop on a plane and leave the country? Gill's argument is devastatingly clear. The Special Counsel used provably false, copy-pasted characterizations to trick a federal judge into signing a gag order, entirely to hide the fact that they were digging into the political opposition's toll records. Let's scale up the scope of this investigation to our next core topic, the multi-member dragnet. Gill reveals that this wasn't an isolated incident targeting Kevin McCarthy. In May of 2023, Jack Smith's office expanded this digital dragnet, quietly issuing subpoenas for the toll records of 9 sitting U.S. senators and an additional member of the House of Representatives. Just like before, every single one of these invasive data grabs was accompanied by a non-disclosure order. Smith repeatedly hides behind the phrase, consistent with department policy and law, but Gill exposes the systemic nature of this secrecy. If a special counsel can target a dozen lawmakers simultaneously, slap a permanent gag order on the telecom companies, and prevent the lawmakers or the American public from ever discovering it, the executive branch has effectively built a shadow surveillance system over the entire legislature. But the absolute silver bullet of this entire 5-minute transcript comes when Gill reveals internal Department of Justice communications that show conscious litigation risk. Smith tries to distance himself from the legal vulnerabilities of these subpoenas, claiming the decisions were made with the concurrence of the Public Integrity section. But Gill puts an internal email on the screen from John Keller at Public Integrity directly to Smith's team. The email says explicitly, "As you are aware, there is some litigation risk regarding whether compelled disclosure of toll records of a member's legislative calls violates the speech or debate clause in the D.C. Circuit." Keller even writes that under current case law, the bar on compelled disclosure is absolute. This changes the entire narrative. Smith can no longer claim this was a routine, risk-free investigation. His own legal advisors warned him in writing that what he was doing was skating on thin, potentially unconstitutional ice. Look at how Gill beautifully details the final, cynical calculation of the special counsel's office. He reads the very last sentence of that internal DOJ email. "Given my understanding of the low likelihood that any of the members listed below would be charged, the litigation risk should be minimal here." This is an extraordinary revelation of bureaucratic cynicism. Gill completely dismantles Jack Smith's defense by spelling out the exact logic the DOJ used. "We are using a highly volatile, unconstitutional legal theory. We aren't actually going to charge any of these senators, which means nobody will ever find out about it. Nobody will have standing to sue us, so who cares? Let's just grab the data anyway." Gill frames this not as an honest mistake, but as a deliberate, calculated subversion of constitutional guardrails. They used secrecy orders to ensure their novel legal theories would never face the scrutiny of an open court or an adversarial defense attorney. As the gavel falls and Gill declares Smith's actions an absolutely disgraceful walk all over the Constitution, we are left staring at a profound systemic crisis. On one side of this debate, you have the institutional defenders of the Department of Justice who believe that a special counsel investigating an unprecedented event like January 6 must have the latitude to trace every phone record, even if it belongs to a senator or a speaker, using standard legal tools. On the other side, you have the terrifying reality exposed by Gill, an unaccountable prosecutor using rubber-stamped secrecy orders to spy on elected officials while consciously acknowledging they are violating constitutional privileges because they know they won't get caught. Who do you trust with this kind of unchecked power? If Gill's paper trail is accurate, the guardrails built to protect our separation of powers didn't fail. They were actively bypassed by designers who knew exactly how to avoid detection. This transcript is a terrifying reminder that in the modern digital age, the line between legitimate federal oversight and a politicized surveillance state is razor-thin, and the fight over who watches the watchman is far from over.